You are listening to a free version of the Majority Report with Sam Steeder. To support this show and get another 15 minutes of daily program, go to majority.fm, please.
The Majority Report with Sam Steeder.
It's Thursday, November 15th, 2018. My name is Michael Brooks, and this is the 5-time award-winning Majority Report. We're broadcasting live steps from the industrially ravaged Gowanus Canal in the heartland of America, downtown Brooklyn, USA. On today's program, an interview that Sam just recorded called The Schoolhouse Gate, Public Education, the Supreme Court, and the Battle for the American Mind with Justin Driver. It's going to be a half-day episode as Sam is not here, and we are going to duck out and skip the fun half today, but we will be here in full force tomorrow. A few more headlines for you, which we will get to tomorrow. Pod Save America caught in a much bigger story about Facebook, and a story that should be used to remove Chuck Schumer as head of the Senate majority. The U.S. House has blocked a resolution to end U.S. military support in Yemen. Trump suggests that Republicans lost because people put on disguises to vote illegally. I hope he does not find Matt's Phantom of the Opera mask. A federal judge weighs a delay as a deadline looms for the Florida recount. And Cuba has announced that they are pulling thousands of doctors out of Brazil, which was part of a significant collaboration between the Workers' Party government and Cuba to deliver health care to the Brazilian people, even as the Brazilian regime, we can call it at this point, attempts to level new charges at political prisoner Lula da Silva. Those are some headlines. We're going to be back live tomorrow. But first, I got to tell you about a few things. 2018 has been a difficult year for human rights. But have you ever wondered how rights abuses are documented around the world? You probably have, with the sheer volume of global crises we're seeing, from civilian casualties in Syria to ethnic cleansing in Myanmar to the caging of children on U.S. borders. It's crucial that we expose the truth in order to defend rights of all and bring those responsible to justice. Human Rights Watch does just that. They're an independent, non-for-profit organization known for their They are an independent, non-profit organization known for their accurate fact-finding, impartial reporting, and targeted advocacy, often in partnership with local activists and human rights groups. They accept no money from any government, but they rely on the support of informed, dedicated people just like you. So if human rights are important to you, visit hrw.org/majority to make a donation and support its work around the world. When you do, not only is your gift tax deductible, it will be matched dollar for dollar until 2019. That means your donation will go twice as far to advance justice and defend basic dignity of people who need it most. Again, that's hrw.org/majority. And also, I think this is a perspective we all share. Life is too short for bad Wi-Fi. Thankfully, Eero, E-E-R-O, home Wi-Fi brings you fast, reliable connection in every room of the house. Not to mention the second generation Eero and Eero Beacon allow you to build a Wi-Fi system that's more perfectly tailored to your home than ever before. When you add Eero Plus, you'll get a total network protection with the ability to block malicious and unwanted content across your entire network. Sam, I bet, is all over this. By checking the sites you visit against a database of millions of known threats, Eero prevents you from accidentally visiting malicious sites without slowing anything down. And this is incredibly helpful because we all know that the internet is just like a cesspool. It's like everything. Eero Plus automatically tags sites that contain violent, illegal, or adult content, so you can choose what your kids can and cannot visit right from the Eero app. You can also get rid of annoying ads and pop-ups, awesome, on all your devices. And blocking improves load times for ad-heavy sites, so you can browse and stream faster than ever before. I've honestly just started using it, and as I say, what is always a big deal for me with all of these things is ease of installation, because I don't like to have to figure anything out. It's incredibly easy to set up. It makes it a lot easier to do research for me, as an example, because a lot of the sites that we use to get sound clips, as an example, are just deluged with ads and pop-ups, and getting out of that situation is like breathing clean air. And it's faster. It's just all around better than, particularly the Wi-Fi. Actually, there's a lot of very slow Wi-Fi in Brooklyn, believe it or not. And it was incredibly easy to set up. I set it up without any help, without calling anybody. That should speak volumes. Never think about Wi-Fi again. Get $100 off. Get $100 off of the Eero Ease unit and 2 beacons package, and a year off Eero Plus. Just visit eero.com/majority. Enter code majority at checkout. That's EERO.com/majority, and code majority at checkout. And continue with plugs. Tomorrow, we're all here. Tomorrow there is a special, usually Tuesday nights, obviously, but TMBS is going to be streaming live at Friday tomorrow at 7 p.m. We're going to do it on the Michael Brooks Show YouTube channel. ContraPoint and Corey Pine are the guests. There's going to be a sartorial surprise in store for tomorrow. And check out the Bell House to get your tickets to the Michael Brooks Show, and also check out, which is at February 1st, and also check out the Bell House to get your tickets to the Majority Report show, which is on January 12th? January 13th at Podfest. See you, hopefully. Matt and I will see you at both of those events.
Oh, yeah. Be pros by that point.
Indeed. And, all the ways you can hook up with Majority Report and TMBS. Jamie.
All right. So I am actually going away to Mexico for 10 days.
Sweet.
Starting tomorrow.
Hell yeah.
I'm very, very excited to visit our Zapatista comrades who make the coffee for justcoffee.coop. But in the meantime, we have some great content for all you Antifada super soldiers out there. We have our episode on the Greek debt crisis out now, and I really encourage people to listen to it even if you don't think you know anything about economics, because I think it's really important to understand this stuff. Bourgeois economists don't want you to understand it. They want you to think it's too complicated for you to understand, but I think it's important if you're an Antifada fan, perhaps not a fan of capitalism, to understand things like the Greek debt crisis. We also have a bonus episode with the same guest, Pavlos Rufos, about some of the uprisings that happened in Greece recently, as well as a crossover episode that Sean did with our friend Jake Flores at Pod Damn America on the history of the IWW. And I believe our producer Andy is also doing an interview with Noel Ignatiev of the magazine Race Trader. So check it out.
Dope. Matt.
Literary Hangover. Check it out on YouTube, podcasts, and patreon.com/literary hangover.
Perfecto. All right, folks. We will, of course, be here tomorrow. Anna Kasparian and David Feldman guests. And stay tuned now for Sam's brand new interview with Justin Driver on the Supreme Court and the future of public education.
We are back. Sam Cedar on the Majority Report on the phone. It is a pleasure to welcome to the program Justin Driver. He is the Harry N. Wyatt Professor of Law at the University of Chicago Law School, and he is the author of The Schoolhouse Gate, Public Education, the Supreme Court, and the Battle for the American Mind. Justin, welcome to the program.
Glad to be with you, Sam.
So, from your perspective, the public education is the one of, if not the most, I guess, the epicenter of constitutional interpretation as we look back on the body of constitutional law in this country.
That's exactly right. It seems to me that when one steps back and examines constitutional law, it's fascinating how often the anxieties that exist in the larger American country come to be battled at in the school context. And so if you think about, Brown versus Board of Education and battles about patriotism and equality and liberty, these cases arising from public schools are often significant of larger anxieties that exist in the country.
And we should say the cases that you hand on here are constitutional cases as opposed to statutory. And I think that is just to clarify for people, because there's obviously plenty of constitutional questions over the course of this country's history in regard to public school. But I have to say too that there's I'm a little bit reminded. I spoke to Carol Anderson about her most recent book, One Person, No Vote, and the Supreme Court in its relationship to the vote in particular, is another lens in which to look at the history of this country. And what I'm struck about, and I think we see it here too, because you start with you break down by topic, sort of the history of the Supreme Court in dealing with these constitutional questions. But you start with the court's early encounters with race, culture, religion, and patriotism within the context of the schools. And you return at least to the question of race later in the history of the Supreme Court. So let's start with those early encounters. What were the seminal cases that within the context of public schools that dealt with race and culture and religion in the early years of this country?
Yeah, there are a few cases that spring to mind that were decided a very long time ago that have important resonance in modern America. Let me give you two examples. One would be a case called Pierce versus Society of Sisters, where Oregon sought to require all children to attend public schools. The fear at the time was that folks attending Catholic schools were insufficiently American because they attended Catholic schools. And so this was a referendum that was pushed by the Ku Klux Klan, who thought that if we get rid of these private and in particular parochial schools, we will have one united nation and a sort of nativist impulse and everything. So obviously there are ugly echoes of that exist in American society today. Another example of a major case from the 1940s is the Barnett case, where localities sought to require students to pledge allegiance to the American flag, and if they refused to do so, they were going to be expelled. And so this raised problems in particular for Jehovah's Witness students who believed that it violated their religious faith in order to recite the Pledge of Allegiance. The Supreme Court of the United States invalidated that measure and said that the freedom of speech involves a corollary right not to speak, that you have the ability to remain silent during the Pledge of Allegiance. And of course, that has lots of echoes today with the Colin Kaepernick situation and the NFL protests more broadly.
Well, I mean, and I'm struck by that. The right not to speak has implications even in the context of the Janus case.
Oh, yes.
I mean, to contextualize the importance of these cases, I mean, it would be your argument that there's a lot of interpretations of the Constitution that start in the context of public schools, but disseminate that ultimately then get applied across society. And I mean, right?
That's exactly correct. That's exactly correct. So the Barnett decision announces the right not to speak. There's a prohibition on compulsory speech, and exactly as you suggest, that has applications well beyond the Schoolhouse Gate. Another example of this phenomenon where cases that begin in schools spill over into the larger society would be Brown versus Board of Education, right? The most celebrated opinion, certainly from the 20th century, and perhaps in all of American history. There's a prohibition on Jim Crow that Brown says itself is sort of limited to education. But over time, of course, the prohibition on Jim Crow, official laws requiring children to attend separate schools, went beyond the educational context. So this is yet another reason, exactly as you suggest, that the schoolhouse is a particularly vivid and captivating prism through which to examine broader constitutional phenomena.
All right, and I want to return to Brown versus Board of Education, but let's stay with that law in Oregon, and I believe it was in the 1920s that the KKK had supported banning private. And as a way of banning essentially parochial schools. On what grounds did the court find that students had the right to attend to, or that there should, I guess there should be an exception? I mean, how did they tell us what the construction of that case was, and what the sort of constitutional principle that came out of that, and where that principle has led us down the road?
Yeah, so this is a case from the 1920s. The court said in Pierce versus Society of Sisters that this law violates the Constitution. In particular, they are thinking about a fundamental right, and they are thinking about a liberty component. The most famous sentence from this opinion says that the child is not the mere creature of the state, meaning that the state cannot do whatever it wishes with individual children. And so this is one of a trio of opinions written by Justice McReynolds, a widely reviled jurist, with good reason, I should say. He was an anti-Semite, a racist, a sexist. But in this particular instance, I think that Justice McReynolds was correct to say that it would violate the Constitution to say that you cannot have private or parochial schools.
And so let's move forward in time as we talk about freedom of expression. Tell us what some of the seminal cases in terms of freedom of expression within the context of schools, and what the implications were that for those outside of it. And we just mentioned one in terms of the Jehovah's Witness can't be compelled to speech. I would imagine also, now that I think about it, that would have also impacted the Hobby Lobby decision within the context of the ACA on some level.
That's right. So that's one of the really interesting parts of this book, in my view, is that the court for a while did an admirable job in protecting student speech. The most famous case in this area is the Tinker versus Des Moines case, where during the 1960s, students in Des Moines, Iowa, want to wear black armbands in protest of the Vietnam War. School officials get wind of this plan, and they say, oh no, this is too hot button of an issue. It's worth saying that this protest happened in 1965, long before the mass mobilization against the Vietnam War. And the school administrators say that there's a student from Des Moines who graduated from this high school, and he still has friends here, and this person died over in Vietnam. And his buddies who are still here, they are going to view you as dishonoring his legacy if you wear this black armband. The Supreme Court upholds the right to wear these black armbands and says, and this gives me the title for my book, it can hardly be argued that students shed their constitutional rights at the Schoolhouse Gate. There was a vehement dissent in the case written by Justice Black, who says that this is a terrible decision. Students are there to be seen and not heard. And while the court did a really admirable job in Tinker in recognizing student speech, over time, the court has announced a number of exceptions to the core rule at Tinker, and so it's a deep irony, exactly as you're suggesting, Sam, that the Roberts Court has a much venerated, at least in certain circles, reputation for defending the freedom of speech. Indeed, some people believe that it's recognized the freedom of speech in areas where it doesn't properly belong. But one area where they have fallen down rather consistently is in the area of student speech, including in a case that was decided when I was a law clerk at the Supreme Court called Morse versus Frederick. Of course, no one calls it by that name. Everybody instead calls it the Bong Hits for Jesus case.
Tell us about the Bong Hits for Jesus case.
Yeah, happy to do so. That's a case that was out of Juneau, Alaska, where a high school senior, took a banner to school that was 14 foot long, and he stands across the street from the school while a parade is happening in honor of the Olympic torch making its way through Juneau, Alaska. Joseph Frederick, he's an 18-year-old senior. He unfurls the banner. The principal sees the banner, marches across the street, grabs it out of his hand, and then proceeds to suspend him. And the question is, does this violate the freedom of speech? The court, in an opinion by Chief Justice Roberts, says it does not violate the freedom of speech. He says, if the principal reasonably believes that the speech in question is designed to promote illicit drug use, then it's permissible to punish the student for the speech. This is very unusual from a First Amendment perspective because you're generally required to be viewpoint neutral. You're not allowed to silence one side of the debate with an idea that the marketplace of ideas should function properly. Justice Stevens wrote a really important and quite convincing, in my view, dissenting opinion where he was quite elderly in 2007, and he said, I can remember the days of prohibition. And why should we not view Joseph Frederick as trying to participate in a growing debate about the legality of marijuana? He's participating in this debate perhaps inarticulately, but the principle that Stevens was trying to identify is that what's illegal today can become legal tomorrow. And it seems to me with the 11 years that have passed since that dissenting opinion, Justice Stevens' argument assumes added force.
Would a Roberts court, I guess we still have one, in fact, maybe even more Robertsy than before in some respects, would that same court rule that a non-student couldn't do that banner? I mean, to what extent? I mean, was this a question of what the relationship was between the student and the principal, or the student and whoever was receiving the message?
The Roberts Court would not say that if this were just an ordinary person in a public park that had a banner, they would not say you could be punished for that speech. And so the court, it's a good question, Sam, because the court conceived of this as a school event, and so for these purposes, it may as well have taken place in the lunchroom or something like that. And so, these were very unusual facts, and so many observers were surprised when the court decided to grant certiorari, that is to say, agree to resolve this case at all, because it was so unlikely to be repeated. And there are many important debates that divide the lower courts where they really do need some guidance, including with respect to, say, off-campus speech, what can students say online, and then it makes its way to school and be punished for. But the court has routinely ducked these issues. And another important area would be with respect to speech about gay equality, which has been a number of high-profile lower court decisions, but the Supreme Court has yet to get involved in this area.
Was there a principle that derived from that case? In other words, because that ultimately creates a limiting principle for the First Amendment rights, right, of students. And I'm not quite clear on how you would articulate those limited principles because of the facts in the case. But has that structure been the principle that was created there? Has that been applied to other areas of free speech within our society?
It's a very shrewd question that you ask because a number of people suggested at the time that this rule that Chief Justice Roberts came up with about it being permissible to punish students for pro-drug speech would not be confined to that area. Roberts suggested that because drugs are a particular hazard to youth, then it was permissible because this was an especially important area. But lower court judges have, exactly as you anticipate, imported this principle to areas that don't have anything to do with drug usage at all. And so people say, well, there are other important issues that exist in schools, and so why shouldn't we make it permissible to punish students for this type of speech, including in a lower court opinion written by Judge Richard Posner, one of the most formidable Court of Appeals judges in recent history. He tried to import the logic of Morse versus Frederick to an area that had nothing to do with drugs.
And was that confined to something in the school? In other words, like this type of principle, right, can go one of two ways. It can apply back to other aspects of school, but it can also end up being a principle that's applied in society at large.
No, this is confined to schools. People have not tried to take the logic of Morse versus Frederick and apply it out to non-student situations would be the most effective way to say that, because there are, as I suggested a moment ago, some decent amount of speech that's uttered by students happens when they are not within the schools, but instead when they are online and, at home. So they're not in school technically, but people have applied it certainly to that extent. But people have not taken the logic of the Bong Hits for Jesus case and said, okay, you are a 25-year-old person who said something. This is covered by Bong Hits for Jesus. No one's been quite that aggressive.
There's still time, I guess. Let's talk about the Brown versus Board of Education. This is a case that I guess was resolved in 1954. I imagine it worked its way up in the years before that. Just tell us what was at issue here with this case. And I think it's. I sometimes I think people lose sight of just how long these Jim Crow laws basically lasted in our society, and just tell us what the issues were there, and then we'll jump ahead to this century, where some of these things were unwound a bit. But let's start with there.
So Brown versus Board of Education is a decision from 1954. It's a unanimous opinion, and it invalidates regimes that are found in 21 different states that either permit or require racial segregation in schools. And as I suggested at the beginning of our time, Brown versus Board of Education is a widely venerated opinion. Every justice on the current Supreme Court believes that Brown versus Board of Education was correctly decided, but that is true because they ascribe radically different meanings to Brown versus Board of Education. The opinion was incredibly sphinx-like, and people thought it meant different things. Did Brown require integration, or did it merely forbid segregation? Many people would view those things as being synonymous, but Brown set off a fierce debate to control the meaning of Brown, and over time, it seems clear to me that people who are conservative and have a colorblind vision of constitutional law in effect co-opted the meaning of Brown in order to forbid even, in my view, legitimate programs designed to promote racial integration in our public schools. Can we
go through how that happens? Because I think one of the interesting things I think that people should understand is we're headed into an era where there is at least I'm a little bit cynical about it. I suspect you might be a little bit too, particularly having a clerk for Breyer. But that this notion of original intent, and that the Constitution says what it says, and we as judges or justices are here to just interpret the plain meaning of the case. But yet we're talking about cases that have been resolved in the modern era with people writing, not only their briefs, but everything is fully documented, and yet the principles that are adjudicated in this case that was unanimous are reinterpreted in the way that people with a certain hoped outcome have on some level, or certain ideological framework. So, I mean, tell us how. What principles were reinterpreted and how? The best way to do this is to think about a single individual and his effort that ultimately proved successful to co-opt the meaning of Brown. Senator Sam Ervin of North Carolina was a graduate of Harvard Law School. He served on the North Carolina Supreme Court, and he was a segregationist and also a sophisticated legal thinker. I say that without admiration with respect to the way that he used his sophistication. On the heels of Brown, Senator Ervin said, Brown versus Board of Education is a deplorable decision, but it's also not as drastic as people think. And over time, he stopped saying it was deplorable when it became clear that Brown versus Board of Education was not going to be overturned. And instead, he focused his attention on, in effect, taming the meaning of Brown by saying that it doesn't require integration. It merely forbids segregation. Indeed, he would say that Brown versus Board of Education, properly conceived, forbids race consciousness on the part of school districts, even if they are trying to bring about racial integration and bring people together. And so Senator Sam Ervin made these moves in the 1950s into the 1960s, and he, again, initially was saying Brown was wrongly decided, and then says Brown doesn't mean all that much at all. And over time, this carried the day, including in a case that was decided in 2007 when I was a law clerk for Justice Breyer in a case called Parents Involved in Community Schools. Should I tell you about that case? Yeah, this is there's actually two cases, if I'm not mistaken, where a case out of Seattle, that Parents Involved in Community Schools, and one out of Louisville, which I think was Meredith versus Jefferson County, where they were combined, where we saw go ahead. I mean, it begins to unravel Brown versus Board of Education.
That's right. So you're exactly right. These are programs in Louisville, Kentucky, and Seattle, Washington, and the school boards get together and say, we, like many cities in the United States, have racial isolation in our neighborhoods, and if we simply send people to the closest school to them, we're going to have racially isolated schools. And so in order to combat that, they have race-conscious admissions practices where people are allowed to rank their preferences of schools, and then within reason, they would take account of race in order to try to ensure that the schools reflect the larger racial diversity of the cities. Chief Justice Roberts writes an opinion where he says these programs are unconstitutional because they are, in effect, the exact same from a constitutional perspective as the Jim Crow era. Chief Justice Roberts says, Brown versus Board of Education invalidated programs that told children where they could go to school based on the color of their skin. These programs in Louisville and Seattle tell students where they can go to school based on the color of their skin. It matters not one whit from a constitutional perspective that programs in the modern era are designed to bring people together, and in the bad old days, they were programs that were designed to keep people apart and indeed keep racial minorities subordinated. My old boss, Justice Breyer, wrote a very long, impassioned dissent where he says this is a cruel distortion of history to compare what happened in Topeka, Kansas in the 1950s to Louisville and Seattle of today, and he offered an integrationist vision of the 14th Amendment. What's really interesting is that Justice Kennedy wrote an opinion only for himself where he sought to split the difference between the Roberts opinion and the Breyer opinion, where he said that schools need not be colorblind in all instances. They can take account of race when they are drawing the district boundaries for schools or when they are building a new school. And this, of course, is important because Justice Kennedy is no longer in the court, and he's been replaced by Kavanaugh, and there's every reason to believe that Kavanaugh will take a more conservative line on these issues in K through 12 education, but also with respect to higher education and affirmative action.
Okay, and I want to just put a marker there as to what the implications of that going to be and what that's going to look like. But what were the constitutional grounds that were found that you can't, because we don't see anything in the Constitution that say you can't consider race when you're setting up public schools, right? I mean, what if the concept is that there must be that there must be some equal treatment under the law? Isn't that basically saying the delivery of services, must be equal in that sense? Or tell us what it was, the principle, what gave room to the idea that you cannot have any race consciousness in the context of setting up public schools?
Well, this goes back to your earlier very shrewd question where you asked about originalism. During the era that the 14th Amendment was ratified, it would be very hard to make the claim that the original public meaning of the 14th Amendment, which is what originalists are supposed to be looking for, required constitutional colorblindness. Of course, Justice Scalia, who was on the court then, and Justice Thomas, who remains on the court today, are the people who are most readily identified with originalism, and they are skeptics of race-conscious decision-making. But during the 19th century, there was, of course, the Freedmen's Bureau and other mechanisms where there was race consciousness. And so you might think that this would require them to uphold the legitimacy of affirmative action if they were true to their guiding principle. But here we don't see any effort whatsoever to deploy originalist thought. Instead, they start with Justice Harlan in his dissenting opinion in Plessy versus Ferguson, where they say our Constitution is colorblind. But of course, that's a dissenting opinion from 1896. And this sort of tension in their jurisprudential approaches, which is an irreconcilable tension in my view, makes people think that originalism is not some sort of just neutral principle, but instead is sort of politics by other means, and they're using their jurisprudential purposes to promote an agenda, a jurisprudential agenda that's associated with the right wing.
That's a polite a way of saying basically they're sort of full of it when they make these arguments, right? I mean because we see this in the context and people should be aware of this dynamic, because we're going to see this in the context of so many other. We saw it in the context of the Voting Rights Amendment, particularly in Section 5. We see this. We're going to see this in the context of Roe v. Wade. It would be my suspicion that there's not going to be a direct overturning of Roe v. Wade, but rather it's going to be reinterpreted in such a way that you could drive a truck through all the instances where the right of a woman's sovereignty over her body, is abridged. And so this dynamic is one we're going to see. I mean, this is like basically the MO, isn't it?
I think you're exactly right. One of the dominant themes of over the last 50 years of the Supreme Court has been the way in which many GOP-appointed justices have drifted left over time. This is true of Justice Kennedy, Justice O'Connor, Justice Stevens, Justice Souter, Justice Blackmun, even Justice Powell can be understood this way. But in recent years, the GOP has been quite shrewd in the appointments that they are making, and they've looked to people who have time working in a Republican presidential administration. That's true of all 5 of the current justices, and this is to say that the days of the right making, in effect, what would turn out to be mistakes in their judicial appointments have come to a close. And so I think that you are exactly right that the current 5 members of the Supreme Court who were appointed by Republican presidents are quite committed to vindicating a conservative vision of the Constitution in a way that we have not seen. So for supporters of women's reproductive freedom and for affirmative action and many other areas besides, it seems as though we are entering, some very dark times indeed. I should say that in the area that I write about most in the book, that I am actually somewhat hopeful that there may be a way to cobble together a coalition of liberals and the libertarian-inflected vision of constitutional law that is ascendant in some right-leaning circles. And so I hope that a coalition will be possible to vindicate student speech rights. If you're a libertarian, you're skeptical of state authority in that realm. The Fourth Amendment, dealing with suspicionless drug searches, which is our major area. And then the single issue that I care the most about in this book is the issue of corporal punishment, which still exists in this great nation of ours.
I want to touch on that in a moment. I was shocked to find out 22 states still have this. But just to stay for a moment on the implications of Kennedy not being there in the wake of that 2007 ruling, because Kennedy basically opened the door to a practice which is basically seems to me to be the predominant practice now in terms of trying to achieve some type of racial diversity in schools, which is to use other mechanisms which are somewhat associated with racial diversity. It's not one-to-one, but it's looking at economic diversity, for instance, or programs where you're choosing from a varied amount of schools in any district in terms of creating some form of affirmative action. Those are the type of things that would be under assault with a Roberts Court minus Kennedy plus Kavanaugh.
I think that as a formal matter, those sorts of programs that you mentioned, paying attention to wealth or, say, socioeconomic status of the education level of the parents, things that are, as you said, correlated with race, but not race itself, have not been under attack yet. But I think that you are correct to suggest that could be the next frontier. For the moment, people on the right are focusing on race-conscious measures themselves, including racial classifications. But over time, I think you're exactly right to predict that the frontier here could move and become more aggressive, and they will say the reason that you're using, class or parents' education level is because of its racial dimensions, and they would say that is an impermissible purpose. And so even if the means themselves are not race conscious, that the goal itself is impermissible. Of course, if that logic were taken seriously, imagine how that would be applied to, say, legacy admissions in higher education. That could end up boomeranging back, but somehow I have a suspicion that they'll figure out a way to avoid that fate.
Or also its implications on what it would mean for the way that districts are drawn in the context of voting, because there's a lot of that goes on that's not even I think is legitimately sort of like a surrogate. The surrogate's not so far away. But let's talk about corporal punishment, because this is sort of stunning. I had no idea of to the extent that corporal punishment is still legal in this country within the context of schools.
Yeah, that is as I said, the issue that I care the most about, and I think you are far from alone in being unaware that corporal punishment exists, and I believe it's 19 different states where, and we should say what we're talking about here, because corporal punishment is a somewhat, antiseptic term. We're talking about students being struck with wooden paddles. So much so that they sometimes have, bruises that are lasting for days. The court heard a challenge to a corporal punishment regime in the 1970s and issued a decision out of truly egregious facts where a student in junior high school was beaten so savagely that even 3 days after the attack, he had a 6-inch in diameter bruise that was tender, purplish, swollen, and also oozing fluid. He received a whole battery of medical treatment and prescriptions, including pain relievers and cold compresses and sleeping pills and laxatives. He could not return to school for more than 2 weeks and couldn't sit down for 3 weeks without discomfort. The Supreme Court in this decision from 1977 said, unbelievably in my view, this doesn't even qualify as punishment for constitutional purposes. The Eighth Amendment, of course, prohibits cruel and unusual punishment, but Justice Powell wrote the opinion to say that, in effect, it says cruel or unusual punishment that stems from a criminal conviction. And so this is one of these instances where, we heard Kavanaugh during his confirmation hearings talk a lot about the importance of starting with the text of the Constitution, and, that's the guide star. Well, if that's true, then I hope that the court will revisit this issue. As you said, there are about 20 states that have corporal punishment, but in some ways that overstates its prevalence because just 5 states, all located in the Deep South, account for more than 70% of the instances of corporal punishment. And so, if you're committed to being a libertarian and a skepticism of state authority, in what instance is the state exercising dominion over an individual than when they are hitting someone? And we should say that public school students are the sole remaining group of individuals that the government can strike with impunity for just, failing to follow directions.
All right. So, lastly, what do you anticipate? And obviously, we have a whole host of other cases, particularly in the context of funding disparities and immigration and whatnot. But where do you perceive? Are there any cases in the pipeline that you think are going to have particular relevance in the context of schools or in the context of the greater society?
Yeah, one issue that springs to mind is the issue of trans students accessing restrooms. This was a case that the court agreed to hear in a few years back, and then they ultimately decided not to address the matter because the Trump administration rescinded the Obama administration's guidance on this area. And this is one that could be in flux. Justice Kennedy was the foremost vocal proponent on the court's history of gay equality. And many people, of course, associate the trans issue with gay equality. And so Kennedy quite conceivably could have joined the liberals in order to protect students' rights to access the restrooms that are congruent with their gender identity. And there's no reason to believe that Judge Kavanaugh would do it. Another issue to keep an eye on involves unauthorized immigration and students being able to access schools. The court issued a decision in 1982 saying it's impermissible to exclude unauthorized immigrants from public schools. A young lawyer working in the Reagan Department of Justice called John Roberts wrote a memo suggesting that Plyler versus Doe was wrongly decided. And so this is another area where I suspect in the next few years we could hear a legal challenge to Plyler versus Doe. And that would, if the court reversed course, that is a decision that would have catastrophic consequences for our constitutional order.
The book is The Schoolhouse Gate, Public Education, the Supreme Court, and the Battle for the American Mind. Justin Driver, thanks so much for your time today. I really appreciate it.
Thank you for having me, Sam. The pleasure was all mine.
It might take all the strength I got to get to where I want, but I know somehow I'm gonna get there. I wasn't looking when I just got caught between the truth and the light bar. But finding out won't make me feel any better. Yeah, I know the clock is ticking, but the meds are gonna kick in, and my pilot light shining bright. I get somewhere the choice was made, for the option where you don't get paid, for the road that bends before it finally breaks you. I guess somehow I lost my drive between the 101 and the 5. Do you know how far the detour takes you? Yeah, I know the clock is ticking, but the meds are gonna kick in, and my pilot light shining bright. The months drifted into years while I shifted